Ready? Start. A bare reading of this provision makes it clear that the prerequisite to exercise of jurisdiction by the Commissioner suo motu is erroneous insofar as it is prejudicial to the interests of the revenue stock. The Commissioner has to be satisfied with two conditions, and there can be no doubt that the provision cannot be invoked to correct each and every type of mistakes of error committed by the assessing officer. Stop. It is only when an order is erroneous that section will be attracted. Stop. An incorrect assumption of fact or an incorrect application of the law will satisfy the requirement of the order being erroneous. Stop. The phrase prejudicial to the interests of the revenue is not an expression of art and is not defined in the act. Stop. Understood in its ordinary meaning, it is of wide import and is not confined to loss of tax. Stop. Para. In this context, it must be regarded as involving a conception of acts or orders which are subversive of the administration of revenue. Stop. There must be some grievous error in the order passed by the income tax officer which might set a bad trend or pattern for similar assessments which on a board reckoning the commissioner might think to be prejudicial to the interests of revenue administration. Stop. In our view, the interpretation is to narrow the merit acceptance. Stop. The scheme of the Act is to levy and collect tax in accordance with the provisions of the Act, and this task is entrusted to the revenue. Stop. If due to an erroneous order of the income tax officer, the revenue is losing tax lawfully payable by a person, it will certainly be prejudicial to the interests of the revenue. Stop. The phrase prejudicial to the interests of the revenue has to be read in conjunction with an erroneous order passed by the assessing officer. Stop. Every loss of revenue is a consequence of an order of assessing officer cannot be treated as prejudicial to the interests of the revenue. For example, when an income tax officer adopted one of the courses permissible in law and it has resulted in loss of revenue, or where two views are possible and the income tax officer has taken one view with which the commissioner does not agree, it can be treated as an erroneous order prejudicial to the interests of the revenue unless the view taken by the income tax officer is unsustainable in law. Stop. It has been held by this court that where a sum not earned by a person is assessed as income in his hands on his so offering, the order passed by the assessing officer accepting the same as such will be erroneous and prejudicial to the interests of the revenue. Stop. In the instant case, the commissioner noted that the income tax officer passed the order of nil assessment without application of mind. Stop. Indeed, the High Court recorded the finding that the income tax officer failed to apply his mind to the case in all perspective and the order passed by him was erroneous. Stop.